Yo, folks! Oh, I did not plan for a stream today. I planned to have an update on something, maybe having some fun or something else, but then something pissed me off royally. It posted that video a couple of hours ago, so you who've seen it, oh, you know. If you know, you know. If you haven't seen it, you can actually pause now, go watch that video, and be prepared for what this stream is going to be. Let's just say, Big Nick, folks, you know, maybe you don't. When you hear the things, words like things are going down, and some girls will put their hair in ponytail. This guy is letting his hair out because I'm going to go Samson on fuckers today. Oh, yeah, already cursing. So, I knew that Justin ImALiar, he filed some garbage. And then yesterday there was a hearing, and it's so obvious that friends and family of Justin made accounts to troll the community around Kelsey this past weekend. Because seriously, what? Black screen over my face? Can you see me now? You should be able to see me. I don't have anything here. Does this work? Black screen over? What the fuck is going on? All right. See, now, yeah, why shouldn't that? I'm already worked up. Why not this as well? Okay. Well, you heard me saying words, and yeah, it's so obvious, as I said, that Justin's friends, family, I guess the see you next Tuesday former bridal party is a part of the crap that went on social media during this weekend. It's obvious that they have been looking forever for something to say about Kelsey that is negative. It is so obvious it's bullshit. And I'm going to start with Justice for Kelsey Fitzsimmons account on X. Where did I go now? What in the actual fuck is going on? There I am! Something is very weird. Well, just read. From yesterday. No witnesses were heard today in court. The judge reviewed the motions and has yet to rule. She also reviewed how the visits were going. She shut down the talk about this alleged incident. The incident being allegedly Kelsey being drunk out of her tits at a bar some time ago. And the judge noted that allegations don't automatically lead to barriers. Quote, they must be valid. Also of note, Justin's attorney, Christy Candela, was present yesterday as opposed to Peter Chieko, started to, quote-unquote, explain the alleged incident and was admonished by the judge not to insert herself as a witness by testifying. She claimed to have spoken to the owner of the bar, lest she be disqualified. Now, what does that mean? Well, Here's how you normally do this. If you have a witness that makes claims, then you get an affidavit, sworn under oath, under the penalty of perjury, that is then presented to court. As an attorney, if you just recite what somebody else says, first of all, hearsay. Second of all, you are now testifying in front of a judge. That makes you a witness. The fact that they didn't have an affidavit speaks volumes, because that now all of a sudden now it's just a rumor. And it seems like this bar owner didn't want to put her name on a sworn statement. And that's the owner of the bar. We don't know if the owner worked that night. If she only heard in passing something from a bartender who might have misunderstood the entire situation. We don't know, since nobody put their fucking name to it. Now, this was spoiled by Justin's friends and family, also known as... Oh, I have words for those people. But the CUNTs, the See You Next Tuesday people in the former bridal party, we saw them testifying. Some of them testifying in Kelsey Fitzsimmons' trial. Kelsey, you are so much better without these people. Because is it Mean Girl vibes? I would say bunch of women believing they are 10s who are not even local 10s. They might be local 5s, believing they are local 10s. For some odd reason, jealousy is my... All of a sudden, Kelsey had the life they were supposed to have. She was going to have the life they dreamt of, and they couldn't handle it. And I don't know why they turned on her. I don't care, really, why they turned on her. All we know is that these women who deserves ugly bridesmaids dresses are just bad people. And one or some of these, including Justin's family, decided to, hey, let's spread these rumors on social media. Oh, wait until the hearing. You're going to hear so much about this alleged incident. Well, first of all, let's... The allegation is Kelsey took one drink at this bar and all of a sudden went haywire. Well, that is... Now, if the claim... Now, one of the rumors is, oh, she was hammered when she got there. Well, that if she was hammered when she got there and she was still served alcohol, well, that is stuff that could remove liquor licenses. Now, if there really was just one drink and she went haywire almost as if she was drugged, well, where's the police report? There isn't one. Either because it never happened or because the bar owner suddenly realized, oh shit, I spread a rumor, I shouldn't have done that. And then, because she owns a bar, she doesn't need bad publicity. These fuckers, former bridesmaids and friends and family of Justin, they are maybe 10 to 15 people. I would suggest to you guys that actual friends of Kelsey outnumber these fuckers a whole lot. So maybe bar owner should apologize and hope she doesn't alienate the entire crowd. Because once a bar gets a bad rep, you're basically in bankruptcy. But I thought that rumor and the fact that they didn't get an affidavit, the fact that the Justin's attorney almost disqualified herself by making herself a witness, putting her credibility to the court at stake. Now, what we're about to read, all of a sudden, will be a whole lot more fun. Because Justin, or as I believe, one of his sisters and his mother compiled, because Justin is not this smart. He really isn't. Sorry, Kelsey. You're a gorgeous woman. You have a wonderful kid, and you deserve all the best in the world. But for the love of God, get better taste in men. Okay? All right, folks. So this is what we're going to snark out on today. This is what Justin filed. I believe he filed this, May 22nd at 4:05 p.m. Making, that was, when was that? Friday. Making it basically impossible for Kelsey's attorneys to file a proper response to this bullshit. So it was planned. All right, are you ready, folks? Because I'm going to have some fun here. Commonwealth of blah 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 blah. Father's verified opposition to mother's motion for further temporary orders. Now comes the plaintiff, Justice C. ImALiar, hereinafter father, through counsel, and files his verified opposition to the defendant Kelsey E. Fitzsimmons, hereinafter mother. Motion for further temporary orders filed on or about May 18th, 2026. The father requests this honorable court deny mother's motion for further temporary orders. In support hereof, the father states as follows. Brief background and procedural history. Let's see how many errors we can spot in this motherfucker. Okay? Well, hi Slidey over at Rumble. Only on Rumble and YouTube today. I'm going to just in the YouTube chat. If you have a Rumble account, don't mind if you follow me over there. Okay. Brief background. The parties were never married, thank God, and have one child together. Caden, who is 15 months old. The parties last resided together with the child at this former address until on or about June 27th, 2025. I'm quite sure when he filed the original filing that he didn't live there anymore. That he lived with mommy because he's a loser. The father resides with the child at his parents' home. Because he's a loser. Upon information and belief, let's not say that address, father is employed as an EMT firefighter with the North Andover Fire Department and is currently on paid administrative leave. You're omitting something here, aren't you, Justin? Why you are on still on paid administrative leave? It's because you're a pothead. You smoke weed in enough amounts that would make Willie Nelson jealous. The mother was formerly employed as a police officer. Mother's law enforcement certification was suspended upon information and belief. Mother's employment with the town of North Andover was terminated. It is unknown as to whether or not mother is presently employed. This, folks, makes no fucking difference when it comes to custody. If he knows or not, because it's not his fucking business. On or about June 30th, the father sought and obtained an emergency abuse prevention order, blah, 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 with false information. Remember that? Because Kelsey was already cleared to go back to work. She had worked through her postpartum depression. I mean, she was doing fine. And you couldn't handle that. Because you wanted to be a pothead for the rest of your life, being a fucking loser who couldn't take care of yourself and your... and I assume it's your sisters, or your mother who couldn't handle you being... Well, you're a loser, Justin. That's the plain word of it. So I bet your sisters and mother, once you showed up at mommy's and daddy's house, they knew that you were more or less relinquishing your parental rights. And they couldn't have that. So they took charge over Justin because Justin is a fucking loser. And with the help... and that's how this was filed falsely. Let's continue. And then he omits what actually happened during all of that. That his actions almost got the mother of his child killed. Mm-hmm. And this is sought and obtained an emergency abuse prevention order. This is ex parte. You didn't notify Kelsey, because this is the thing in Massachusetts, is that one party can ask the court and one-sidedly can kidnap the child from its mother. Or the other way around. It doesn't discriminate in that way. It's absolutely ridiculous. And then he filed for a complaint for custody, support parenting time. And then August 8th, yada, yada, yada. By the way, during this is when Kelsey was fighting for her life in hospital, when he filed all of this. And then October 22nd, 2025, the mother filed an assented to motion to file answer and counterclaim late, which was allowed by the court. Yeah, because she was in a hospital basically dying, you motherfucker. On or about October 21st, 2025, the parties entered into stipulation for temporary orders on plaintiff's verified motion for temporary orders, which provided impertinent part as follows. This was the time when she was... in October. Was she back in jail then? Because of the judge who then fucked off? I think so. So, all of this... Kelsey had no fucking choice. None. Until the criminal case was done. And now, yeah. Yeah, you know all of this. You will follow everything. Yeah, okay. The parties further acknowledged that mother is currently being held without bail. Yada, yada, yada. Pending a criminal trial. Yada, yada, yada. This, yeah, as such, mother shall have no parenting time. Yeah, no shit, Sherlock. She's in jail. Held without bail. Now, that worked itself out sometime later. But at that time, yeah, of course, the court has no choice. And also, they are omitting a whole lot of information. And then child support, I bet he thought he would get a lot. He got $12 per week in child support. Oh. And then yada yada yada. He tried to get the entirety of the proceeds of Kelsey selling the house. He tried. No, he didn't get it. He tried to get the mother of his child completely without means to defend herself. And then health insurance, yada yada yada, daycare, yada yada yada, yada yada yada. Yeah. And on or about October 27th, yeah, all of this. I think we went through this a few months ago. On or about October 28th, the parties filed a joint affidavit of colloquy relative to the stipulation, blah, 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 blah. Temporary order, da-da-da, none of the, yeah. And now let's get to, now there's a big jump between October 30th to March 11th. Mother's motion for further temporary orders and an affidavit in support thereof, yeah. On or about April 3rd, filed plaintiff's verified motion for appointment of guardian ad litem and plaintiff's verified motion for further temporary orders. On or about April 14th, at the 10-day review hearing. I don't think they had a 10-day review here. I don't. Hearing filed is 209A abuse prevention order. The parties filed a stipulation of the parties to extend and modify 209A. This is after the trial was done and she was acquitted. They should never have filed any charges. It was obvious, the copy shorter, that he lied. It was stupid obvious, folks. Because I don't remember his name because he's meaningless to me. But according to that cop, in a area that was basically 1 foot wide and 3 foot long, she simultaneously dove for the weapon, took steps back, still pointed the gun at his face at the well, first he said 3 foot, but that would make the barrel of the gun being inside his head, so his measurements are quite off. I'm betting that cop, that is how he measures his peen. Very, very optimistically, and with a sugar cube and tweezers. Oh, look at that. Hey, from Marielle, thank you so much. $20. Can't stay long, Nick. This case is so upsetting to me, but saw your earlier video. I wanted to do something to make your day a little bit better. Oh, thank you so much. It actually does. It actually does. Thank you so much. Oh, thank you. And I see Dave is here also. What case is this? It is the Kelsey Fitzsimmons family probate case. And this is Justin failing in filing a rumor as evidence. Yeah, so with that cop, I don't. Poor people in North Andover being protected by that jack off. Thank you, and thank you again to Marielle. Thank you so much. Let's continue. The parties agreed to extend and modify the 209A abuse prevention orders. These deleted. All other provisions of the order shall remain in full force and effect. Yeah, for a finite period of 90 days. What does that mean? Well, basically, it means let's get rid of the heavy stuff. Kelsey wants to prove to the court that she is perfectly capable of adjusting to this in order to gain custody rights. I don't blame her. She could go the route of scorched earth, but she chooses cooperation. Something the ImALiar family doesn't know the meaning of, which this filing here will show. The parties have entered into this stipulation with the benefit of advice of counsel. On or about April 14th, the court modified and extended the 209 abuse prevention order in accordance with the stipulation of the parties accepted by the court, attached hereto, and incorporated by reference herein. A review hearing is scheduled for July 13th in Lawrence before Judge Ulwick. And then they have this footnote. Notably, paragraph 1, the no abuse provision, and paragraph 12, the provision requiring mother to surrender all firearms to the North Andover Police Department, suspending mother's license to carry an FID card, and prohibiting mother from possessing and or purchasing firearms and ammunition are still in effect. Yeah, until the 90 days are over. She's voluntarily doing this in order to get her parenting rights back after your false filing, Justin. She is fighting your evil with kindness. And I bet this is starting to get apparent to the court who is the bad guy. On or about April 27th, father filed father's verified opposition to mother's motion for further temporary orders. April 27th, mother filed mother's verified opposition to father's verified motions for further. On or about May 1st, after a hearing on April 28th on the parties' cross motions for further temporary orders, the court issued a temporary order which states, in pertinent part, which means Justin is removing the things that sounds bad for him. Custody. The child's primary residence shall continue with the father. Yeah. Accordingly to the prior ruling. Supervised parenting time. The mother shall have supervised parenting time with the child every other Saturday and Sunday from 10 a.m. to 2 p.m. with a professional supervisor in the community or in the maternal grandmother's home. Visits shall commence on Saturday, May 9th. On Mother's Day, May 10th, mother's parenting time may be extended to 4 p.m. Mother's immediate family may be present for the visits. Mother shall be responsible for the costs associated with the supervised visits. Yeah. She is coughing up the cash in order to get her child back. And then the order was, after 1 month of successful parenting time, the mother shall continue to have every other weekend parenting time supervised, and in addition, parenting time every Wednesday from 5 p.m. to 7:30 p.m. supervised by the maternal grandmother. Yeah. So they are slowly getting the child back to Kelsey so they get to know each other again. Communication. The father shall provide through counsel weekly updates regarding the child, including medical appointments, developmental milestones, and a general update on the child's growth and development. Yeah. The court declines to order substance abuse testing at this time without prejudice. Yeah. And why is that? She's not a junkie like you, Justin. And she has shown that over and over and over again. Guardian ad litem. The request for appointment of a Category E guardian ad litem shall be reviewed at the next scheduled hearing and determined by the assigned judge. This matter will be reviewed on May 26, 2026 at 8:30 a.m. That was the hearing yesterday. All previous orders not specifically addressed herein shall remain in full force. Yeah. On or about May 18th, mother filed mother's motion for further temporary orders, requesting that the same be heard on May 26th, the same day as the review hearing. Yeah. There's nothing wrong with this. Argument. The father's primary concern is and always has been the child's safety and well-being. You remember the video of when the cops went in to grab the child? Do you remember what Justin did? When the cop handed the baby to him, boom, and immediately handed over to his sister. Seriously, Justin? That is how you show that, oh, I'm the father of the year? But just, yeah, take the thing, I'm going to grab stuff. You fucking loser. By that act, you showed you don't give a shit about your kid. That is why you're still why you moved in with mommy and daddy. Because you're a child yourself. A grown-ass man, but you are a child. All right, let's continue. Then they go to our family wizard. Mother is seeking an order from this court requiring the parties to communicate through our family wizard regarding the child's medical appointments, developmental milestones, and other general updates concerning the child's growth and development. Mother is also seeking the provision of the temporary order dated May 1st, 2026, relative to father sending weekly updates through counsel be terminated. I don't think that is correct. Let's see footnote 2. Footnote 2. It should be noted that the father has fully complied with this order, as well as the prior temporary order dated October 28th, whereby the parties agree that the father would share updates about the child, as well as photographs and or videos of the child through counsel on the 15th and 30th of every month. Okay. Father is not opposed to communicating with the mother via our family wizard relative to the child. Yeah, here's the problem. You wrote to Kelsey on that app that you would not continue to communicate with her and only via counsel. That's in evidence, Justin. So father is not opposed to communicating? Well, your own fucking words says you do. They continue with, in fact, in father's verified motion for further temporary orders filed on April 3rd, 2026, father expressly requested an order from the court that the parties shall forthwith download OFW. The parties shall communicate via OFW only, absent emergency relative to the child. The parties shall not disseminate or copy any OFW communications between them except with their respective legal counsel. Yeah, but why did you then tell Kelsey basically to fuck off? Oh yeah, did you not tell that to your counsel before this crap was written and sent in? Did you forget about that? Or did your mommy tell you to not tell your attorney? Was it that, Justin? Was it mommy who told you to omit facts to your counsel? The relief father sought mirrored the relief mother sought in a motion, yada yada yada. As such, the only difference between the parties requested relief is that the father also sought an order prohibiting either party from disseminating or copying any OFW communications between them, except as necessary with their respective counsel. So, again, you, Justin, you told Kelsey you didn't want to talk to her via OFW. All right, continuing here. Both parties' motion for further temporary orders were heard by this court on April 28th. However, the temporary order dated May 1st, does not require the parties to communicate via OFW, but merely requires the father provide a weekly update to mother through counsel relative to the child's growth, development, and general well-being. Nevertheless, immediately following the motion hearing on April 28th, and in good faith, both parties downloaded OFW and began communicating about the child on that application. As this court is well aware, this matter has been the subject of media and public attention since its inception. Both parties, as well as the child, have been subjected to online scrutiny by individuals unknown to them. Very, very few have scrutinized Kelsey. Now, there are a half dozen content creators, but they are medically retarded to begin with, so I don't count them. The scrutiny against Justin is based solely on Justin's actions. If he stopped being a man-child and grew up and acted as an adult, it all goes away. It actually does. I don't want to cover this. This case should have been done and over the moment Kelsey was acquitted. Had we seen that the custody in family court and everything, that all of that went smoothly, we would have been gone by now, moved on. But you keep filing this absolute horseshit garbage. This is the Streisand effect, Justin. Or Afroman effect. If you're being a moron, we will tell you you're being a moron. Let's continue. In fact, at each court hearing in this matter, new crews and or social media bloggers have been in attendance recording the hearings. Yeah, which they are allowed to, protected by First Amendment. Pleadings filed by both parties have been the subject of several hour-long podcasts and related online commentary. Yeah, it's public documents, and you're being an asshole. Yeah, I'm going to comment on it. As such, Father merely sought a court order that ensured that any and all communications between the parties would not be disseminated, copied, or shared on social media or the internet. Curiously, when the father presented this provision to Mother in form of a stipulation, Mother refused to agree. I am quite certain that the stipulation, if I remember correctly, you basically wanted to ban the entirety of internet to talk about it. That is a stipulation that Kelsey can't agree to. Because only a moron would try to have such a stipulation. These parties have a long road of parenting ahead, and any unnecessary tension and drama by unknown individuals is not beneficial to anyone involved, especially the party's young child. This is the first time in this filing at page 8 that we see Justin trying to care about his child. And how does he do it? By using the child as a weapon. You disgraceful man-child moron. That is what you use? No. You do not have the authority to play that card. This is you whining and bitching, trying to save yourself from criticism. For similar reasons, in father's verified motion for further temporary orders filed on April 3rd, father also sought an order prohibiting both parties from posting photographs and/or videos of the child and all communications relative to the child, including but not limited to communications on our family visit, on the internet, and on any and all form of social blah 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 blah. Again, the mother refused to agree to such a provision. This is not the entire of that quote. As you see, it starts not with a capital letter, meaning this here was much, much longer, including but not limited to. He basically told her, you need to stop your supporters from talking about this. She can't agree to such a provision because she does not control what we do. As a matter of fact, Justin, you have more control over what we do. And when you file shit like this, you got our attention. Prior to the motion hearing on April 28th, the mother spent approximately 2.5 hours with the child and father on Saturday, April 25th, in the presence of counsel at a visit suggested and facilitated by father without any court order requiring him to do so. Yeah, that was not out of goodness of your heart. That is so you could, more or less, oh, look how good I am. Selfish reasons. Immediately prior to the visit, the parties through counsel agreed in writing that no photographs of the visit will be posted or disseminated on any form of social media, nor released to the press of any kind. Nevertheless, the mother posted a photograph of herself and the child from that visit. That April 20. I'm quite sure, because I have not seen anything from that date. We saw something around. When's Mother's Day? That's May 10th. I can. I think this is. Although the photograph did not depict the child's face, so she didn't post a picture of. Oh, for fuck's sake! You whining man-child. While the court's temporary order dated May 1st did not specifically address the parties' posting of content regarding the child on social media and on the internet, the court was clear that the child's safety is the primary concern and that such posting are not in the child's best interests. Up until May 10th, the only person bringing the child into public and have it photographed was you, Justin. You. Mother states in the instant motion that the language father proposed relative to the parties posting the child and or communication related to the child on the internet and or social media demands that mother manage third parties and what they post, which mother can clearly not do. Yeah. The language proposed by father regarding posting content related to the child on the internet and on social media clearly prohibits the parties from posting photographs and or videos of the child and communication between them concerning the child, and provides that neither party shall permit any third party to do so. Do you see here? This is not in quotation. That is not quoted. Because this is how you can see that an attorney has gone through this bullshit. Because these are not within quotation marks. And it's ridiculous for them to think that we won't notice. Or in this specific case, me with a law degree. You think I don't notice these things? Fucker! I do this for a living! That's it's so stupid. I don't think a judge in Massachusetts will fail to notice it as well. But they try. According to Merriam-Webster dictionary, permit is defined to... This is just stupid. Because this is not quotation. In other words, father is seeking that neither party shall allow, authorize, cause, or direct a third party from posting such content. See this word? Cause. This, also again, wording is important. That word leaves an opening for Justin to claim, well, even though you shared it on a private whatevers, that caused it to leak. That, for fuck's sake, Justin, and whoever represents you, stop being stupid. Words matter. Wordings matter. This here is them trying to they're trying to open the door for claim. Oh, she caused this to happen. Bullshit. Father understandably has serious concern relative to the child being posted all over the internet, given the heightened media attention that its matter currently has. The child should not be subject to such media attention. But stop being an asshole, Justin. Further, since the verdict was entered in mother's criminal trial, the mother has been increasingly active on the internet, including but not limited to engaging in online interviews and podcasts and publishing poetry online relative to the events that have transpired over the last year that relate to her imprisonment and postpartum mental health struggles. Justin, are you trying to prohibit Kelsey's First Amendment right to talk about her experiences? It sounds like you, for selfish reasons, don't want her to talk about her experiences, about your false 209, which, by the way, if you look closely at it, there are different types of handwriting on it. Meaning, you didn't write it by yourself, did you, Justin? When your sister went with you, you started, as the man-child you are, until your sister took charge, because you're a man-child, and wrote it herself. What she tried to tell you to write. Because you're just a man-child, a whining little man-child. Following mother's supervised parenting time on Mother's Day, mother posted another photograph of her and the child on a private whatevers. While the photograph did not depict the child's face and was shared on a private Instagram account, the mother currently has approximately just under 7,000 Instagram followers, and there is no guarantee that the photograph or similar content will not be further disseminated or viewed beyond her intended audience. Here's the thing, jackass. Just because she has these amounts of followers, if she does it on her private Instagram, that doesn't mean all of them have access to it. only the people that are in her private circle. It's not hard, Justin. After this post, it became evident that the mother was not going to respect fathers or the court's position that the parties limit the child's online exposure. It was at this time that the father decided to refrain from communicating with the mother via OFW. Wait a minute. Didn't you write further up that you didn't do this? So now you're contradicting yourself here, Justin. Now you're contradicting yourself. Which he was doing voluntarily and without a court order requiring him to do so, and abide by the temporary order dated May 1st, wherein father sends mother weekly updates through counsel. It is perplexing and concerning that mother does not appear to share the same concern regarding protecting the child from online scrutiny. This is so bullshit, Justin. The only reason why you want to limit Kelsey's right to talk about the case and her experiences is because it makes you look like an asshole. For the sole motivation to ensure the emotional and physical health and safety of the child and to protect the child from public attention. The child doesn't have public attention. We are overjoyed that Kelsey gets to meet her kid again after you filed false information stealing the child from Kelsey. The entirety of the scrutiny is about you and you alone, Justin. For these reasons, why the father is willing to communicate with the mother via OFW related to the child. No, ho. You just wrote here. It was at this time that the father decided to refrain from communicating with the mother via OFW. And now he's willing to communicate with the mother via OFW. Related to the child, he requests that the parents be prohibited from sharing such communications, as well as any and all photographs and or videos of the child on the internet or on social media, or permitting any third parties to do so. Again, asshole. Kelsey, do not control what we do here. It is impossible for Kelsey to do this. Because you're trying to force her to sign off that she is responsible over what we say. No, jack off. Kelsey has no say in what I do here. None whatsoever. None. And you can't force her to try to assert control. Yeah, and Kelsey said, no one is allowed to badmouth the father of my son. If you do, then you will be removed from my page. Yeah. Love you, Kelsey. But this fucker, I understand why you don't. But the courts cannot say, oh, this Swedish old guy, what he says has any bearing on... they can't say I have bearing over the custody battle. They can't, because I'm not a party. I read from the documents and expose Justin as the man-child he is. And then here, mother alleged that, another footnote, mother alleged that the father posted the child on social media, one specifically in December, with others shared on many other social media, showing the child's face and identity. Upon information and belief, this past December, the father volunteered for the North Andover Fire Department's holiday toy drive. Father believes that the photograph to which mother refers to is a photograph taken of several volunteers at the toy drive, which father and the child were in. These photographs were posted by the town of North Andover on its social media page, not by the father. So, you saw the picture being taken. You knew and apparently saw it was shared. And you didn't care because, it's me, Justin. You know what we could have done? Ring, ring. Hello, town of North Andover. Yeah, that picture of my kid, you know, all the publicity. Can you please remove it? No, he didn't. And to my knowledge, he still hasn't. Because he doesn't give a shit about his kid unless it's a photo op for himself. Which I would imagine that's what mommy told him to do. FaceTime communication. Yada, yada, yada. Yada, yada, yada. Yada, yada, yada. Yeah, this is not interesting. And all of the... because here is the thing. While the case was ultimately closed based on the father being awarded custody and the mother having no contact with the child pursuant to the 209 abuse prevention order, DCF found the allegation of neglect by the mother against the child to be supported. No. What the DCF did, if Department of Children Family, they allow the 209, they follow the court's order. They haven't, to my knowledge, they haven't rendered an opinion other than we are following the court's order. So no, they are taking caution and waiting for the 90-day to expire. Here's the thing. If DCF had found this supported, they would have objected. They would have made filings for you in this court. And they haven't. Let's continue. As is detailed extensively, the father's verified motion for further temporary orders filed April 3rd. Mother has a long history of mental health issues and substance abuse that spanned before, during, and after her pregnancy with the child. Oh, really? Let's see this. Just over 1 year ago, and as a result of mother's erratic and violent behavior, the mother was involuntarily held at the Lawrence General Hospital pursuant to after the mother had to be restrained on the party's kitchen floor. The mother's stepfather had to call 911. As a result of the situation, the mother was placed on administrative leave from her job as a North Andover police officer. That asshole was postpartum depression. It's a sad story, which was handled. She handled it without your help, you coward. The moment she gained independence, the moment she started to say, okay, I can go back to work, that is when you took off. You left, Justin. You left your child and the mother of your child. If you had any concerns about your child, You would have brought the kid with you as you fucked off home to mommy. But you didn't. You didn't care about your kid until your mother told you. Yeah. Let's see here. To date, it remains unclear to the father what mother's current mental status is and what treatment, if any, mother is currently receiving or has received since she allegedly held a gun to her head and pulled the trigger with the intention to kill herself, all while she believed that the child was just downstairs just less than 1 year ago. She has no obligation. None. But she did say in court, and it was shown in court, that she did seek mental health. She got through it. She was about to go back to work. So no, don't buy it. Mother has candidly and publicly acknowledged her mental health struggle, yet has provided father with little information relative to any alleged treatment she is or has received, other than merely providing the names of her providers and the type and dosage of her current prescriptions, some of which she allegedly began taking 2 days ago. So you are getting information, asshole. You're getting information. But here's the thing. Did you ask to get a more substantial information? No. So you decide to say, yeah, I know I never asked for it, but she didn't tell me. Asshole. So this is just what she volunteered. Why? Because she has nothing to hide from the court. She volunteered the information because she has nothing to hide from you. Because I guess she sensed that you were going to try to use this. And now let's go to the absolute bullshit. That was a reminder here. I showed this at the beginning, but let me show you this again. Dun, dun, dun. Justice for Kelsey Fitzsimmons, who were in there. No witnesses were heard today in court. The judge reviewed the motions and has yet to rule. She also reviewed how the visits were going. She shut down the talk about this alleged incident. She noted that allegations don't automatically lead to barriers. They must be valid. Quote. Also of note, Justin's attorney, Christie, was present yesterday as opposed to Peter. Started to explain the alleged incident and was admonished by the judge not to insert herself as a witness by testifying. She claimed to have spoken to the owner of the bar, lest she be disqualified. So yeah. This is a rumor without a signed affidavit from the bar owner, who I strongly suggest discovered, oh shit, I'm risking my license. Oh shit, I just said what somebody else told me. Oh shit, I bet you the bar owner actually doesn't have personal information, only what she's been told. So she can't sign an affidavit. But let's see here. In early May of 2026, meaning a couple of weeks ago, 3 weeks ago, mother was observed at a bar located in Newsbury, Essex, Mass. After being served only one mixed drink, mother began acting aggressively, erratically, and out of control. That sounds like she was drugged. Where's the police report from the bar? There are none. Mother was observing flashing the entire bar and found partially naked in the women's restroom with a male individual. Mother's actions and behavior was observed by several patrons of the bar and she was asked to leave. Mother has been banned from this bar. Do you see what's missing here? An actual affidavit. An actual affidavit saying this is what happened. Here's what might have happened. She went to the bar. She had a drink. Somebody asked her, "Hey, please show us the scar." And she pulled up to show the exit wound. That is now turned into, by this absolute fuck twat, oh, she was flashing the entire bar. No. Found partially naked in a woman's restroom with a male individual. Was she on the toilet with her pants down as a man walked in and then walked out and and then you blew it all out of proportion? Because there's no fucking affidavit to this. None. We know that now. Why? Because your lawyer started to make herself a witness by testifying to hearsay to hearsay. Because she had jack shit to bring the judge. Jack shit to show the judge. The co-owner of the establishment informed Father's counsel that all staff has been informed that Mother is not to be served and is not welcome at this bar, and this type of behavior is entirely unacceptable. Where's the fucking affidavit, asshole? There is none. Because as your attorney spoke, allegedly, to the co-owner of this bar, who you do not name, the moment this information was told to your attorney, she would write it down and ask, will you sign this affidavit? And she couldn't get a signature. Because all of a sudden, as soon as it is a signature under the penalty of perjury, you're you're in legal trouble if it shows that it was lies. So what happened is that this co-owner said, no, I really can't. I really can't. So this entire section is rumors. And I can almost bet money it was started by either your sisters, your mother, or the horse that was in Kelsey's bridal party. This rumor eventually found its way to the co-owner, who made bad statements. But once she was asked, she or he, I have no idea, was asked, yeah, sign this affidavit where you legally can be held accountable if it turns out to be false. And hell no. Father's counsel was further informed that although the bar contacted the police regarding a potential no trespass order against Mother, the establishment ultimately chose not to pursue the order due to concerns that doing so would escalate the situation. Bullshit. 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 Here's the thing. If they contacted the police, that phone call could be in evidence. So, did they call the police? Because even though there was no charge, the police still writes down, we were contacted by these. They chose not to pursue the no presser. That would be in file. And I guess you didn't find one because I don't think it exists. Mother's behavior made the patrons of the establishment uncomfortable, and at least one patron left the bar as a result of Mother's behavior. Rumors. Pure, unadulterated rumors. Again, probably started by either your sisters, your mother, or the horse in Kelsey's former bridal party. And continue. This type of erratic and aggressive behavior, which Mother has a long history of exhibiting, this is meaningless. Judge, the rumors that we started and we almost fooled a bar owner to testify about didn't work out. But trust me, bro. No. We don't trust you, Justin. Because you're a liar. It's extreme, especially when the mother represented to this court less than 1 month ago that she is currently engaged in ongoing mental health counseling and that she is compliant with prescribed medication. Yeah! She was almost killed by her colleague. PTSD from being shot. She is still injured. It takes years to heal if you ever get healed from that type of injury. Of fucking course she is in counseling. And she's open with it. And you try to use it as a weapon. Asshole. Father has still never been informed as to what Mother is being treated for. You don't have that right, motherfucker. Father is deeply concerned about the status of Mother's mental health and substance use. What substance use? Nowhere in this fucking file do you specify. Okay, what substance? Okay? Tell us, Justin. What substance? What substance? You don't specify it, but you make claims. But you don't show actual evidence. Zero evidence. All while there are, if I remember correctly, correct me if I'm wrong, chat, there are over 200 videos of you sneaking out of the house during her Kelsey's pregnancy, after your child was born, where you go outside to get high and then go to work high. Your credibility is fucked, Justin. Given the foregoing, it's the father's position that the party should continue to adhere to the step-up reunification parenting plan established in the temporary order. If you're this extraordinarily worried with this bullshit example, why are you adhering to the step-up reunification parenting plan? Shouldn't you be, with this example, if it exists, be opposing it altogether? Asking the court, yeah, you need mandatory drug testing. Yeah, you need mandatory this and this and this until she can show blah, 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 blah. No, you don't. Because you know it's bullshit, Justin. This verified opposition for further supported by such argument that may be advanced by counsel at the time of hearing. Yeah. And we know how that went. Your lawyer was told to shut the fuck up, or I'm disqualifying you from the case because you are trying to make yourself a witness instead of bringing actual evidence. That backfired spectacularly. And here is to protect the establishment from potential public scrutiny. Father intentionally omits the name of the bar from this pleading. As the establishment has expressed concern about possibly safety issues and retribution, Father will provide the name of the established to the court upon request. And basically they just said, shut the fuck up. I'm not interested. Wherefore, Father respectfully requests that this court deny Mother's motion for further temporary orders. Certificate of copy. Yeah, and we all know, know today what actually happened. Your attorney tries to, you file this with the court. Your attorney tried to testify about what was said, which the judge said, no, you don't. Because it makes you a witness, dear counsel, which this would disqualify you from being an attorney on the case. And she clamped shut, your attorney. So unless you actually show sworn affidavit under the penalty of perjury, what you just did was showing the court that you are prepared to bullshit the court about anything. And still, despite claiming that you are so worried, you still want, no, let the reunification plan move forward. If you were that worried, and if all the things you said were true, why wouldn't you fight for sole custody? Well, if you did, all of a sudden, the amount of evidence you have to present to the court has to be substantiated. And you have nothing, Justin. Nothing. You should count your stars that Kelsey doesn't want to go scorched earth on you. She just wants her kid back. And she will. My guess is after this 90-day period has passed, which is in July, I think. End of July or whatever it is. The court will order joint custody. Not legal advice, but here's my advice to you, Justin. Stop filing this bullshit. Just be really, really happy that Kelsey isn't suing you, your sisters, your mother, and the horse from her former bridal party from now to Kingdom Come. Be happy she joined custody. And that is all she wants. Because she could clean you out. All right, folks. That is what I had for you. I had a lot of snark to get out of me. And again, if you wonder why I am especially snarky today, go watch the video. It's 7 minutes about something that really pissed me off today. I'm going to post the link in the chats to that video. It's also on Rumble. Go watch it and you understand why I'm having an especially bad day today. And yeah, tomorrow, well, let's see, Friday, next on the schedule. Friday, of course, is Slightly Bust Show. I don't think we are going to talk about the Kelsey case. We might talk about the Delphi case. We will we won't talk about the Laura Owens case because for you who know, or maybe you don't know, attorney Laura's attorney, his wife passed away. So I'm putting a pause on especially not Laura Owens, but that part of the Laura Owens case. I also saw on Dave Neal's channel that Gingrich actually apologized. Well, sort of. It's one of these backhanded apology, but still an apology to Dave Neal and to Omar. If that means that it's going to be a turnaround with Gingrich, I'm going to leave him alone. First, because he needs time to grieve. He needs time to process. And he needs time to give himself a chance to be better. Okay, folks. That is what I had for you. Thank you. Thank you for being here. Thank you for allowing me to do this. Thank you to Marielle for the $20 super chat. Thank you so much. That is so nice of you. To Mr. Jingles, from Mr. Jingles and myself again. Thank you. It's thanks to you guys I'm doing this. And keep a lookout regarding the Delphi case because I'm going to Delphi, Indiana in September for the oral argument in the appeals case. I will also go to Hamlet, Indiana, because I'm going to find Fossler. You know Fossler from the Aaron Spencer case. I'm going to go to Hamlet and I'm going to see what I can find. So I really need you to watch my videos because I need some cash and funds to be able to do all of that in September. I might do a self-promoted fundraiser for that as well. All right, folks. Thank you again. I hope I never have to talk about the Kelsey Fitzsimmons case ever again. I really hope. I really hope this will be the last time I talk about that fucking case. I'm quite sure it won't be because Justin surrounds himself with bad people. All right. See ya. Have a good one and remember to hug your families. Unless your family's shit, then screw them and give your love to the people who deserve it. See ya.